So we often complain about the fact that majority of the people don't really go through an estate planning session. They don't structure their affairs before they pass away. But I think the nicest thing is finding out that there's a few that actually believe that this is important and take up those steps and go through an estate planning session. And others even try to structure their affairs on their own accord to ensure that when they pass away, at least there's not a lot, their family is going to struggle with. And that is commendable, right? But we have to note that when people sometimes are going through these estate planning sessions or structuring their own affairs, they tend to make a few mistakes here. And today, I want us to just pinpoint just 3 mistakes, right? Or 3 options that people tend to exercise, which don't really tend to have positive outcomes. So I often say, just be mindful if you're going to exercise any of these 3 mistakes when it comes to estate planning or structuring your affairs. So without further ado, let's get to the discussion. But before we do so, to those that are new here, my name is Yolanda Mnyangeza and I'm an attorney and a director at Mnyangeza Attorneys. We're happy to see you here, right? So let's get to the discussion. Now, the first of these options, which I say normally is a bit of a mistake or doesn't really have positive consequences at times, is the option of people moving ownership of their movable property to their own children. And majority of the time when you talk to people about this, they say they exercise this option so that when they pass away, their kids don't have to now transfer the properties from the deceased estate to their names. And secondly, they tend to say that they do this so that children can avoid administration or probate court, right? As much as the intention is good, this is not necessarily a good idea. Here's why it's not a good idea. First things first, once you move ownership, from yourself to your child, it means that you are no longer in power here. You don't have authority with regards to that property, which means full control is with your child. Which means what? Which means that child tomorrow can decide to kick you out of that property. And I've had quite a few of these cases, and people tend to not understand this. They tend to think that because they have probably moved, this for a good purpose to their kids, that's going to protect them, or the law is going to protect them. No. Once you move title to your kids, away from yourself, it means that you are relinquishing all the rights you had with regards to that property. So by tomorrow, you could be homeless, right? And the second thing is that it might be detrimental to you. Let's say your child didn't kick you out. Now you have difficult circumstances. You would like to sell that immovable property. How can you sell it? Because now it's not even yours. It belongs to the child. Right? So which means you don't even have authority to try and do this. So you take away those special rights that you have, as much as you had good intentions. Another option with regards to the same issue that people love to exercise is to move their properties to their minor children. Biggest mistake. Again, it's limiting you so much in the sense that there's nothing you can ever do with regards to that property now. More especially if you are in South Africa. For instance, in South Africa, once a property is owned by a minor, you need specific permissions to even try to sell it. And even when you do succeed at getting those permissions, you don't get the proceeds of selling that property. It goes to the government guardians fund because that money is that of the minor. So a minor's interests are always protected. So which means that you have lost that property. It's no longer yours anymore. And people tend to find this out later on. So hence I'm saying, before you exercise this option, understand it, think about it clearly, then decide whether or not it's a good option. And majority of the time, it's not really a good option. Now, the second thing that I always say that be mindful of before you exercise it as an option, understand the consequences, is you drafting a joint will with your spouse or your partner. Remember, you drafting a joint will means that you guys have meeting of the minds about how you want your things, to be inherited after the both of you have passed away. But here's the downfall about a joint will that a lot of people tend to discover after. First things first, When, for instance, the first one has passed away, you are now the surviving spouse. You will not be able to change the terms and conditions of that will, irrespective. Normally, when you're alive, you're able to change a will every other month, every day, as much as you like. You have that freedom. But now, when you've drafted a joint will and the first spouse has passed away, you can't change it anymore. You will be governed by those terms and conditions. So if, for instance, you said that, or in that joint will, you're meant to benefit all of your kids, in equal shares, all of your properties, you can't change those terms. Even if there's a child now that you feel should not be here, unfortunately, the will stand. The second disadvantage about a joint will that often people don't note is that once this will is presented to the master in South Africa, the master of the High Court, everybody will have access to it. It will be visible to the public, right? So, which means that you cannot hide it anymore because it will be readily available and people can have access to it. So you can't hide anymore that people are going to be worth how much when you're not there, which tends to be a bit risky, right? So that is the other disadvantage of a joint will. The other one, which is the last one that I'm going to talk about, that tends to not sit well with a lot of people and which they tend to find out later, is the fact that, with regards to a joint will, if, for instance, the property after the second dying spouse has to go to a certain person, you can no longer do anything with regards to that property once the first one has passed away. Which means that if you would like to sell this property now, because of that condition that property is meant to go to that particular child or those children after you, you can't do anything with that property. You can't sell it, you can't mortgage it, you can't do nothing because there is that condition now that after you, it is a must that those kids benefit. So now you're restricted. With regards to your own properties, now you can't do anything. You are in a tight corner here. You'd like to make use of this property. Let's say you have more than one property and all of these properties have been, are going to be inherited in this regard. So it means that you're stuck. And don't forget, situations and circumstances change. So you really need to be mindful about drafting such a will and understand the underlying consequences. You don't want to be those ones that understand and get to hear about these consequences once the other spouse has passed away, because by then there isn't much that can be done. And then the third and final thing that I often say that just be mindful of before you do it is naming a minor child as the beneficiary of your estate. Right? I know that you want your child to be the one to benefit from the things you have, but be mindful of them actually being the ones who are meant to inherit on their personal basis, right? The reason why I say this is because you need to understand what happens when a child is meant to receive or is a beneficiary in terms of a will and they are still a minor. Because they don't have the capacity to inherit, what tends to happen then is that the money is moved to the government guardians fund and it is controlled there, which means that the guardian, who's the person looking after the child, constantly has to apply to the government guardians fund to get certain funds to take care of the child. And the unfortunate part there is that constantly paperwork has to be provided to the Guardians Fund before they make consideration of this. And as you and I would know, raising a child often is not confined in paperwork. Some of their needs cannot necessarily be documented, right? So which means that there may be some restrictions in that regard, and probably the amount might not be, enough for the kind of standard that you had set for your own kid, right? So instead, what do I often say think about or consider instead of naming this child as a minor, as a beneficiary? Rather think about establishing a trust either when you're still alive or in your actual will, which means that the child will benefit according to your terms and conditions. If you say the Guardians Fund must get 15,000 a month, that is what they will get, because that's the kind of standard that you've placed for your kids. That's the kind of standard you believe should be upheld for your children in order for them to live a comfortable life. But you can't dictate to this if you name that child as a beneficiary, right? If you're not really keen and into these trusts, you just want to protect your child's interests, you can then check when your child is 18, change your will. You don't have to have this trust, but it's also a helpful tool if you want to ensure that you structure your kids' finances, right? But that's just an option to consider because of what happens when a minor child gets to inherit from your estate. So that brings us to the end of the discussion that we were having. So I hope this is going to help you, and I hope that you're going to be mindful of these 3 things going forward, because I'd rather you make the decision knowing the consequences and how they may affect you. Obviously, I always say that sit down with your legal practitioner, try to, engage with them if any of these options are what you really want to consider, right? So let's see each other next time. Like I always say, share if you found this helpful or educative. Share the link or the video. Subscribe. Come back, because we will be sharing more information and education. My name is Yolanda Mnyengeza, and I'm an attorney and a director at Mnyengeza Attorneys. I'll see you next time.